As a California personal injury attorney, I get asked quite often about joint and several liability. It may sound confusing, but it's really not. Joint and several liability applies to the situation where there are two parties, or sometimes several parties, who acted negligently and caused injury to another person. In this case, the negligent parties can be held jointly and severally liable in a personal injury lawsuit filed by the injured person. This means that the injured party can go after any one of the negligent parties for the entire judgment amount, even if that party was not 100% responsible for the injury. If this happens, then one of the negligent parties can go after another one of the negligent parties for reimbursement of that portion of the damages that he or she is responsible for. It's important to know, however, that under California law, joint and several liability applies only to economic damages, like attorney's fees and medical costs. It does not apply to non-economic damages like pain and suffering and emotional distress. You've suffered enough if you've been hurt in an accident. You should not experience further suffering by having to hunt down every single person who may have contributed to your injury. Let joint and several liability help you collect the compensation you rightfully deserve. If you've been injured by more than one party here in California, we invite you to contact us here at Shouse Law Group. We will fight to get you the financial compensation that you deserve.